The topic that I'm presenting on is a fairly mixed bag of issues. Common construction contract disputes. You can spend days talking about something like this because it brings together a collection of different issues. So I'm putting up a brief outline on the screen, and I'll just walk you through what my presentation is going to look like overall. So the first thing that I think is important to talk about to create a framework for understanding common sources of construction disputes is understanding the allocation of risk from the outset of a construction contract. So in other words, at the time when you're negotiating the contract, at the time when the provisions are being finalized, how should risk best be allocated? This isn't a presentation on project structures and contract and drafting contract provisions, but that's to sort of frame the rest of the presentation and to give you some context. And then within that topic, I'd like to discuss some common examples of provisions that give rise to construction disputes once that risk has been allocated in a certain way. Then I'm going to focus on a couple of very common a couple of provisions that very commonly give rise to questions and give rise to construction disputes. First being pay when paid clauses, which I know that there's a cross-section of people in the room, some owners, some contractors, some architects. I'm sure you're all familiar, or many of you are familiar with the term pay when paid clauses. It's a subject of quite a bit of discussion in the industry. I'm going to talk about some cases that have been decided on those types of provisions. I'm going to talk about liquidated damage provisions briefly. That's another popular source of discussion. And then a couple of recent Supreme Court of Canada decisions are going to frame the next two topics that I'm going to cover. So as I said, it's a very mixed bag. The first being something called a contractual duty of honesty, based upon a recent Supreme Court of decision in a case called Bhasin. Now, many of you might wonder if this means that you were permitted to be dishonest in your contractual dealings before the Supreme Court of the Supreme Court of Canada decision came out. It's a question I've heard actually quite a few times in discussing this decision. It's an interesting question. Sandra Stolfo this afternoon is actually going to focus quite a bit on that case in terms of the factual background that gave rise to it. I'm not going to talk about that so much, but I want to focus on the implications of the decision for the construction industry and for construction disputes. And then finally, this fifth topic is a little bit different than the others. But I'm going to talk about process a bit because there's another recent Supreme Court of Canada decision, not in the construction industry, but from last year, called the SATFA decision, that talks about sort of appeal rights in an arbitration and how contracts, are to be interpreted for the purpose of determining appeal rights. And I think that it's a bit of a lawyer's topic, but I think that has some appeal within the construction industry in the sense of understanding what you're getting into when you get into an arbitration versus litigation, and how the dispute resolution provisions of a construction contract can in of themselves inform the disputes and be a common source of disputes in of themselves. So dealing with allocation of risk, I'd like to break that down further into three different components. So firstly, at the outset of a construction contract, it's important to identify what the key risks are, obviously, before you can consider how to allocate them. So this is almost like a checklist you would want to go through in forming your construction contract. What are the risks that I'm getting into as an owner, as a contractor, as an architect, and taking on this contract? Secondly, now that I have identified those risks, what's the appropriate allocation of risk as between the different parties who are involved? And within that heading, we can think about the factors that would be used to determine how to appropriately allocate that risk. And then finally, what are some of the contract provisions, the mechanical contract provisions that are used to allocate that risk? And I'm going to talk about some common examples that many of you may be familiar with. I appreciate there will be a range of experience in the room. So again, if you want to ask me questions about, I can't give you legal advice, but if you want to ask me questions about different examples that have come up, or you want to make comments, then I would welcome that. I've listed some of the risks that I've commonly encountered. This is a list that could be much longer, but these are the things that often give rise to construction disputes. I say design and design errors. So it's important to say not just design errors, but design, because errors is sort of a presumptuous term, and there are many, many disputes over clarity of design, who's responsible for design, how that responsibility is allocated under the contract, what happens when there's a design change. So that's a very common source of dispute. Unanticipated site conditions, that's something many of you who deal with tunneling contracts, for example, might commonly encounter. Or we're going to hear about hidden defects, I believe, from Ken Krupa this afternoon. You can even have unanticipated site conditions arising in a renovation project where you get behind a wall and there's something that no one understood was there. Like thinking about my own home renovation when we were thrilled to find some ducts behind our wall that weren't anticipated. Changes in scope. But not only changes in scope, but also, I think even more importantly, certainty of scope. So notwithstanding all of the advice that we can give you as lawyers about the terms and conditions of your contract and how they can be drafted to allocate risk in an appropriate and efficient manner, I think the most critical part of the contract is having certainty of scope. What's each party? It seems pretty trite. It seems like an obvious statement to make, but it's a very, very common source of disputes. What's each party obligated to do? How do the drawings and the specifications work together? What document do you look at to figure out what each party is responsible for? These are very basic things that when you sit down to litigate a claim, if you ever find yourself in that position, you realize often wasn't made clear at the outset of the contract, and that's why you're in that position in the first place. Delay is obviously a very common source of construction dispute. How the risk of delay is allocated, when compensation will be paid for delay, to whom it will be paid, when scheduling extensions will be granted, deficient work, of course, or allegations of deficient work. Unique milestones and project requirements. So increasingly today, particularly with many of the complex infrastructure projects, payments are based upon the achievement of certain work milestones as opposed to just the passage of another month of time. So those are critical provisions that could give rise to disputes. And then finally, subcontractor performance and claims. You'll sometimes hear contractors saying, well, we did our job. That was our subcontractor who dropped the ball on that portion of the work, and the contractor could be held responsible for that, depending upon, of course, how the project is structured and how the contracts are entered into. Is it a construction management arrangement? Is it a general contract arrangement? So now that we've identified some of the risks, what are the factors that dictate who is best suited to take on that risk? So if you think about the typical construction pyramid where you have on a design bid build contract, for example, and we'll talk about that, but where you have the owner at the top and then a general contractor and then the consultants retained by the owner and then lots of subcontractors underneath, you have to think about who within that matrix, who within that pyramid is in the best position to absorb certain types of risk, not just because they're large or they have the resources to do it, but what's their industry expertise? Are they the right party to come in and attend to an issue if there's a problem that arises? Because misplaced risk is in no one's interest. When you see these really aggressive contracts that try to, whether it's from a contractor's perspective or from an owner's perspective, if they try to allocate all of the risk onto the other party in circumstances where that's not accounted for in some other way through pricing or scheduling or whatever the case may be, it's ultimately in no one's interest, because the party more often than not is not going to want to take that risk once a problem arises, and then you wind up in a dispute scenario. So sometimes allocating too much risk to the other party can actually in of itself be the source of disputes. The objectives of the project. Is timing critical because of a revenue stream that's going to be generated at a certain point in time? Is the project meant to serve a public or a private purpose? All of these things go into determining who's best positioned to absorb the risk. I'm sure that many of you in the room encounter, increasingly so for years now, design-build projects. I won't ask for a show of hands, but that's obviously become very, very common as opposed to the traditional design, bid, build model. So that also informs how the risk is going to be allocated, where the risk is going to sit. Engineering, procurement, and construction contracts we'll talk about those, are very similar to design-build agreements, and those have a very different risk matrix than a design, bid, build contract where the contractor just builds to a set design that's provided by the owner. Now, this is a very, very basic diagram, and I apologize to any of you who've heard me speak before. You may have seen a couple of these next slides, so I apologize in advance for that, but it's just a handy tool to consider how risk is going to be, how risk is typically allocated. So this simple diagram is just a depiction of a design, bid, build model stipulated price contract. So the idea is that the owner hires a consultant to prepare a design. The project goes out for tender, and then the contractors put in bids to build the work on the basis of a set design. So they're not playing a role in the design of the project. And as I'll point out, this is basically the CCDC2 model. So the design risk in a case like this, of course, rests with the owner. The cost risk rests with the contractor. Why? Because the contractor is agreeing that they're going to build a specific design for a fixed price. So that allocation, as between design and cost, is going to inform the way that you allocate risk under the contract, and it's going to inform the types of provisions that you might select and draft in order to facilitate the allocation of that risk. If there's going to be a design change, then the owner is going to pay for that, and the price is going to be adjusted accordingly, because the contractor's fixed price is to build a set design. And as I mentioned, the CCDC2 2008 is an example of that. And just to elaborate on the graphic I had up on the screen a little bit, you've got a couple of subcontractors underneath who are retained by the contractor. The owner isn't or shouldn't be particularly concerned about the subcontract prices, because the owner is simply retaining a contractor to build to its design for a fixed price. So the owner is not paying on an invoice by invoice basis in terms of the work that suppliers and trades and subcontractors are performing. The owner is typically, as you know, just paying the contractor for the progress of the work. And if the contractor winds up in a situation where the project costs more than anticipated for reasons that are the contractor's responsibility, then that's a risk that the contractor is often taking. An alternate model, but still using a design, bid, build project, is a cost plus arrangement, like a CCDC3, where the contractor is being paid for those subcontractor invoices, plus they're earning a fee on top of that. So that's a variation, and that shifts the risk a little bit. Now, I mentioned design, build. This also very simple diagram up on the screen is intended to depict a design build model, and you can see where the risk shifts. So now the contractor is the design builder, so they're responsible for retaining the design consultant who's designing the whole project, and they're therefore taking on the design risk and they're taking on the cost risk. So the design builder is again building for a fixed fee, but they're responsible for the design, if there's an issue with the design, they're going to have to absorb that cost. They're not going to necessarily get a change for it unless it's a circumstance where you have the owner making changes to the objectives or to the output they're looking for from the contract. And a typical example of that, very recently, well, in the construction world, very recently, there was a new CCDC form issued in 2013, the CCDC 14, which is the new design build stipulated price contract. So again, not a presentation on project structures generally, but I wanted to sort of walk through that for context so that we can consider how risk can then be allocated depending upon the type of project model that you find yourself in. So I mentioned the risk of unanticipated site conditions. So think about what you find under the ground when you're constructing a tunnel, and whether anyone really knows what's going to be there. And typically in those contracts, the contractor will be provided with a package of geotechnical studies. They'll have to review those studies. They'll have the opportunity to come out and inspect the site. Maybe they'll have the opportunity to ask questions of the owner. And the question becomes, in that context, who takes on the risk of a condition that wasn't previously anticipated? And what's a fair allocation of risk in that scenario? Is it fair for the to tell the contractor, well, now that you've had an opportunity to come to the site, now that you have all of the studies that we have, you know everything that we know, so you should take on the risk for unanticipated site conditions. Typically, that risk, by default, you would expect to rest with the owner, because it's the owner's site, and the contractor is coming to build on it. But it's the subject of quite a bit of discussion when you're drafting a contract like this, and certainly when you get into a dispute over unanticipated conditions. So an example of that, of how that's handled, can be found in the CCDC 2. And I've put up on the screen General Condition 6.4, or at least an excerpt from it. So how does it work? If either party discovers a subsurface or otherwise concealed condition that existed prior to the commencement of the work that's different than what would have, or different or would not have been expected at the time that the contract documents were entered into, then it could give rise to a change. It's the consultant who makes that determination. If the contractor or the owner does not agree with the consultant's determination, then the issue goes off to the dispute to be dealt with in accordance with the dispute resolution provisions of the contract. So it doesn't specifically say that the contractor had an obligation to identify all of these risks at the outset before they entered into the contract, and they're therefore taking on the risk. But it sort of assumes that it's going to be the owner who's taking on the risk for material changes in site conditions once the consultant rules on them. So that's what the CCDC 2 says. It's a bit of a balancing act, and then you see lots of non-standard forms of contract that take different approaches. I haven't put in specific language, but I've put in some bullet points that kind of illustrate what some variations on that could be. So you can have a provision that says once the site's been inspected, once all of the contract documents have been reviewed, once all of the reports have been reviewed, the contractor is going to assume all of the risk. That's a pretty expensive contract because the contractor is going to price that into their contract price typically. But when you think about the factors I was listing on the screen before, who's in the best position to absorb that risk? What if your contractor is a massive tunneling contractor who does nothing but build these things all over the world? Are they in a better position to take on that risk than the owner who just has this one-time underground project that they're dealing with, and they feel that they've discharged their due diligence by getting all of the studies done that need to be done? All of those things have to be discussed by the parties, taken into consideration, and ultimately it's going to come through in the contract price, most likely. And then ultimately the parties have to consider that it could potentially be the source of a dispute down the road. And a party who's taking on that risk has to consider how they're going to react in the event that there's an unanticipated condition that's discovered. The other side of the spectrum, you can have a provision that says it's the owner who's responsible for unanticipated site conditions, period. The contractor has no positive obligation to discover them. If they happen to discover them, as in the CCDC2, then they ought to report them. But beyond that, they have no particular obligations, and that creates its own set of problems and its own set of uncertainty. So those are factors to take into consideration. Moving on to a very different type of provision that is a common source of construction disputes. How do you manage contract changes on a project? So I guess a couple of things, and some of you will know this, and some of you may not. The CCDC2 is a standard industry form of contract. It stands for Canadian Construction Documents Committee. And it's a group of people who get together and they meet about 4 times a year, I think, and they spend a lot of time preparing standard form contracts that get updated over the years, and each time a new contract gets released, it's a big, big project. And the idea is to have sort of a balanced approach to developing a contract that will be acceptable in the industry. So there are contractors who participate, architects, owners. There's a lawyer on the committee, and the CCDC2 is just one of the standard form contracts, and the CCDC2 is specifically the stipulated price contract for a design, bid, build model. So sorry, that's just a bit more background on what I was mentioning before. So those contracts contain standard general conditions, and the way that those conditions get amended, the parties are free to amend them. The way that they get amended is the parties create a document called supplementary conditions, and those supplementary conditions get added onto the back of the contract, and they revise the wording of the standard or general conditions that are set out in the CCDC contract. When you're starting out with a CCDC2 or any CCDC contract, the parties are essentially saying, we're going to use this standard form, it's going to govern our relationship on this project, and then they're free to try to amend it to shift the allocation of risk. With respect to that question, it's an issue of what the parties are prepared to negotiate. So if a contractor says that they're not prepared to take on that type of risk at all, then the trade-off the owner would probably be looking for is to see that reflected in the price. So if you have a competitive tender process, then often a contractor might not have that type of discretion, because they're going to say, well, if you bid on this project, this is going to be the form of agreement. There could be some negotiations afterwards, but we as the owner aren't going to be prepared to entertain that kind of risk allocation. So it depends on the specific negotiation. But generally speaking, if parties are getting together and negotiating their form of agreement, or they're negotiating changes to a CCDC2 contract, then a contractor could seek to make those kinds of changes, and it's just a question of whether the owner would be prepared to accept it. In most cases, it's probably not realistic for a contractor to say, we're not going to take any risk for something that we should have identified but didn't, and it's probably also not realistic for a contractor to accept a change that would say the contractor is going to be responsible for all unanticipated site conditions, because the contractor's reaction to that is going to be, well, this is your site that I'm building on. I don't really know what's under there. We may know the same thing, but this is your this is your property I'm building on. That's kind of the starting I think perspectives that people bring to the table, and then it's just a question of the risk that the parties are willing to absorb. So going to the example of a very experienced tunneling contractor who might have experience dealing with that kind of risk, they may have more flexibility in taking on some risk for unanticipated site conditions than in other scenarios. So it's sort of a wishy-washy answer, but the reality is that it's a sort of a function of the parties' risk tolerance, and it's a function of their negotiations. Yeah, the reality is it's a business deal, right? The more risk you try to transfer, the more it gets reflected in the price of the contract. But I guess where it becomes tricky is when you're dealing with a competitive tender, which is most often the case on a large project, and maybe there's less discretion in terms of the risk that's going to be absorbed, and the parties at the same time are trying to put forward a competitive price. So in that scenario, if you take too much of an aggressive stance in terms of trying to transfer the risk to one party or another, it could result in a process where you just get, you get fewer bids, maybe, right? If in an extreme scenario, or you just get prices that are too high. But from the owner's standpoint, if they don't try to transfer some of that risk, then maybe the project becomes unpalatable from their perspective, because at any price it's just too risky to proceed with the project. If they don't have a contractor who's willing to absorb any of the risk within their realm of expertise and experience. So it's a balancing act between the parties, and it's a business negotiation. All of these legal terms and conditions arise within the matrix of two parties negotiating a business deal. And all of this whole concept of allocation of risk is really, it's part of that business deal, and it's part of, what the parties are willing to accept in terms of, what their bottom line is going to be and the prices that they can live with. So it's a question of risk tolerance, really. So when we talk about changes, something that I find that's rarely in a contract, but is often the source of dispute, is just to give you an example, is the document that gets used by a contractor to initiate a change. So we all know that there are change orders that can be negotiated by the parties. There are change directives that can be issued by an owner in circumstances where a change order is not negotiated and the owner wants to tell the contractor to proceed with a change with perhaps with the final price to be determined later. But sometimes contracts are less clear on what a contractor is required to do when they identify that a change is required, and what form they're supposed to use and how they're supposed to provide the owner with notice. And that's something that parties may want to take into consideration when they're preparing their contracts to bring clarity to how changes are going to be processed. Some of the common causes of changes, of course, design changes are a very obvious one. Design errors, if there's a design error, it might result in a change to the drawings, a change to the specifications, and therefore an increase in the contract price or the schedule. We talked about unanticipated conditions. That can, in of itself, give rise to a change. What if you have to change the sequencing of the work, or if you have to change some other element of the work as a result of something that's discovered underground or otherwise? Budget constraints can motivate an owner to make changes. There could be scheduling changes. There's a whole host of factors that can lead to a change. And then the impact, of course, would be either schedule or cost. So where there's a valid change under a contract, it's typically going to impact the contract schedule, or it's going to impact the contract price, or it's going to impact both. You'll sometimes have something called a no-cost change, and I'm sure many of you are familiar with that. But there's always going to be a discussion around, or you've heard that term anyway. I hear there's a bit of a reaction to that. But there's always going to be a discussion when there's a change that arises as to how that's going to impact the price, if at all, and how that's going to impact the schedule, and who's responsible for that. So I started to talk about the documents that are used to reflect changes. Change directives, of course, or the contract will typically contain a provision that says where the owner requires a change and the parties don't immediately agree upon the price, here's how it's going to work. The owner is going to issue a change directive to the contractor. The contractor is going to proceed with the changed work, and the price will be determined by a formula that's set out in the contract, or subsequently be determined by the parties. If there are too many change directives, rather than change orders, that's often going to lead to a dispute, because ultimately, a contractor might say, well, I don't agree with, all these prices or the impact of all the changes are having upon my work. The owner may say the contractor's not being reasonable in trying to negotiate a final price for change orders, and that's why there are so many change directives. So when you see many change directives and not a lot of change orders, that can often give rise to a dispute. Change orders are when the parties it's effectively an amendment to the contract, an amendment to the scope. A change is required, the parties negotiate a document that tells them how the price is going to be impacted, how the schedule is going to be impacted, and they capture that in a change order. There are a lot of change directives. It could definitely create disputes. But the way that you try to handle that when you negotiate the contract is, you have to recognize that there are going to be circumstances. Look, there are going to be disagreements on construction projects. I don't think there's ever been a construction project where there hasn't been a disagreement. So the parties have to understand at the outset that there are going to be circumstances in which, or likely there are going to be circumstances in which a change is required, and they're not going to immediately agree upon the impact of that change. So how do they deal with it without impacting the project schedule? They don't want the contractor to stop working while the change is being negotiated, and they don't want the work to be delayed. So change directives are intended to be a mechanism to address that by giving the owner the ability to say, proceed with the work pursuant to this change. This is how you're going to be paid for it until we decide otherwise. But fundamentally, the parties still have to have a mechanism in the contract for understanding how that's going to be dealt with. Otherwise, you're right. It just, the contractor is being told to do things without any particular agreement, and there's a whole question as to what their obligation is, if any. So often contracts will have a formula for determining what the price is going to be under a change directive in the event that the parties are unable to negotiate a lump sum price for their change order, and it will list a whole bunch of costs that will be taken into consideration in determining that change directive, and it will list step by step how it's going to work. That looks great when the contract is negotiated. In practice, it can become difficult because the parties may still, disagree on the interpretation of those provisions. But the idea is you still have some underlying agreement, at least, in terms of how the change is going to work, where the parties don't negotiate a change order. The owner has some option in terms of how they're going to price the change directive, how they're going to pay the contractor, and then the contractor has the ability to say, well, I don't agree with that in this case, and ultimately it gets resolved pursuant to the dispute resolution provisions of the contract, but the contractor could still go forward with the work on the basis of the structure that the contractor provides for paying the contractor for that change. Kind of that's the solution that these contracts try to implement. And when I say the dispute resolution provisions, typically what that means is if there's usually there's a consultant on a larger project, certainly. So the consultant is the one who makes the first determination as to whether or not as to the ruling under a provision of the contract as to whether a change ought to be granted or not. I appreciate that from a contractor's perspective, there's sometimes some cynicism about about how that works, and I've heard that before. But then if the contractor disagrees with the consultant's finding, then that disagreement goes to the dispute resolution provisions of the contract, which may say that the parties have to first negotiate and then mediate and then arbitrate or litigate. There will be a structure set out. This is a little bit off topic, but actually it reminds me of an important point to make. The CCDC contracts contemplate the appointment of a project mediator at the outset of a construction project. And the idea of the project mediator is that it's someone who's becomes familiar with the project, and then when some dispute like this arises during the course of the contract, they can try to resolve it on the spot by facilitating a negotiation between the parties. And the idea is, rather than saving up all of your disputes to go to a mediation, at the end of the project when everyone's trying to sort of figure out what happened after the fact and reconstruct everything, and they're angry because the number of disputes has really accumulated and built up, they have someone there who can resolve disputes in real time. Not make findings, but make recommendations. What a mediator does is they sort of facilitate a negotiation. In my experience, a project mediator is almost never actually appointed under even though the contract provides for that. And some organizations, for example, the Toronto Construction Association, has gone to great lengths, I know, to try to encourage parties to sort of take advantage of that provision of the contract. I'm in favor of that because you have someone there who knows the project and is there to resolve disputes, and then rather than having this whole buildup of change directives that have to be sort of fought about at the end, you, in theory at least, have someone there who can resolve things on a step-by-step basis as they arise, and they know the project because they've resolved other disputes on the project. They've been there from the beginning. The resistance to it is that it's another cost, right? It's another cost that you're absorbing sort of at the front end of the project. You're hiring on another person, and that's, I guess, that's one of the reasons for resistance. A second reason for resistance is probably that, as with any situation, when you enter into a contract with someone, you're hoping you never really have to. You want to stick the contract in a drawer and build a project together. You don't really want to think about disputes, like any situation, and you don't. You're not anticipating that you're going to get into a whole bunch of fights. You're anticipating that you're going to successfully build a project. And so when you start talking about who's going to resolve your disputes before you even started constructing something, there's sometimes a feeling among parties that you're sort of taking the wrong approach. You're thinking about it the wrong way. But the cost of having someone involved at the outset, the cost of drafting proper contract provisions that allocate risk in a fair and appropriate manner at the front end of the project, is a tiny, tiny fraction of the cost of litigating one of these disputes after the fact. The difference is, I guess, you don't want to have to budget for it at the beginning, and you're kind of forced to pay for that at the end if you get into a dispute. But whatever cost and issues parties are reluctant to think about at the front end to try to avoid these scenarios, to the extent that they can assist in avoiding disputes, they really will help parties avoid significantly greater costs at the back end of the project. So that's my little dispute avoidance speech, which is very much a digression from what I'm talking about at the moment. But I thought that was a good point that you made, and it was worth raising. It was worth commenting on. So I'm going to actually I want to get to some of the other parts of my presentation. So I'll flip through these.
12 minutes or so.
Oh, really? Okay.
Time flies when you have fun.
Okay. So I like a lot of anyway. Well, I won't stereotype lawyers, but I guess I've gone on and on about some of these initial issues, and I'd like to talk about some of the specific things that I identified in my presentation. So just quickly wrapping up these change provisions. There's different ways of pricing changes. You can do it on a time and materials basis, on a lump sum basis. You want the contract to address all of that. The CCDC2 contract, for example, has provisions for both change orders and change directives. If you look at my slides, and again, any typos you have there in your your workbook are corrected on the screen at least. But if you have a look at my slides, you'll see in general terms how the CCDC2 contemplates those issues in Part 6 of the contract. The CCDC2 and other non-standard forms of agreement also deal with how delays are going to be processed under a contract. If the delay is excusable, it means that the contractor is not responsible for it, or sometimes the owner's not responsible for it. The excusable part just means that the party doesn't have to take the hit for the delay, essentially. You can have a compensable excusable delay. So from a contractor's perspective, that means it's not my fault, it's the owner's fault. The owner has to compensate me for and give me a schedule extension. A non-compensable excusable delay means that the contractor might get additional time, but not additional money. And then finally, a non-excusable delay is a delay that's the contractor's fault. And so you want your contract to sort of have a clear mechanism for determining how risk for those delays is going to be allocated, what the process is going to be for identifying delays, for substantiating the cost and the time associated with that delay, and for sort of setting up the mechanics in terms of how those delays are going to be converted into changes, including and then you will also want the contract to deal with the risks of things like force majeure events or so-called acts of God, things that are beyond the parties' control. But I'm going to move ahead a little bit because I want to talk about a couple of the issues that we advertise them in the brochure, so we have to make sure that we get to them. Pay when paid provisions. Or sometimes they're called provisional payment provisions. So essentially, the most common example, the way this works, is a subcontract between a general contractor and a subcontractor. So if you think back to that design, bid, build model I had up on the screen earlier with the owner, the general contractor, and the subcontractors underneath, a subcontract might have some provision in it that says something like, we don't have to pay this, well, we will pay the subcontractor after we're paid by the owner. That's one type of pay when paid provision. Or it might say, we will only pay the subcontractor if we're paid by the owner. They sound similar, but those two types of provisions have been given entirely different treatments by our courts. And it's important to understand the distinction. So I have trouble understanding the distinction, but it's a question of whether these pay when paid provisions are conditional payment provisions or just mere timing provisions. That's the distinction that's been made. So I'd like to discuss, how they've been treated by the courts and whether the courts will typically enforce them. They're totally different than construction lien rights. So there's sometimes this conception that if you have a pay when paid provision, it means you don't have a construction, you no longer have construction lien rights because the timing has worked out such that the payment's not owing to the subcontractor yet. That's not the case. A subcontractor or any of the parties in the construction pyramid can't rely on a pay when paid provision or any contractual provision to say that lien rights have been waived. The subcontractor wouldn't want to rely upon that, but they don't want to. They certainly wouldn't want to take that as extending their lien rights from a subcontractor's perspective. From a contractor's perspective, they wouldn't want to consider that a subcontractor has somehow waived their lien rights by agreeing to a pay when paid provision. There's no relationship between the two. I haven't put this case in my presentation, but there was a case where someone tried that, and the court wanted no part of it. So there's no lien rights are completely separate than contractual provisions that deal with things like pay when paid. A construction lien, which you have 2 hours on this afternoon, so I don't want to. I'm not going to get into that into too much detail, but it's just simply tied to your rights arising from the price of the services and materials that you provide to the project. Period. So there have been two lines of cases in Canadian law, and this change I want you to note in the materials I've cited in this Arnoldin case, the lower court decision. It's actually from 1994. These aren't recent cases, but it's actually the Court of Appeal decision in that Arnoldin case in particular that should have been referenced. And if there's one change to the presentation, that's the one you should note. There's essentially been two lines of authority, or as we say, two lines of cases that have arisen on these pay when paid provisions. There was an Ontario Court of Appeal case from a very long time ago now, the Timbro decision, that essentially said that pay when paid provisions can be enforced when they're clear, when the parties understand what they're getting into. And in this Arnoldin decision that also went to the Court of Appeal in Nova Scotia, the ruling was that the pay when paid provision wouldn't be enforced because it wasn't sufficiently clear. And so the one consistency between these sort of two lines of authority is this notion of clarity. The issue is how the courts interpret clarity and what the expectations are. So this can be illustrated by some very recent decisions. In Manitoba, just a couple of years ago, there was a provisional payment clause at issue, and you can see the language up on the screen, and I've sort of italicized the salient parts of it. The provision said that payments will be made 5 days after the contractor receives payment from the owner. And then for final payment, it says payment will be received by the subcontractor within 5 days after final payment has been received by the contractor. So some of you in the room might conclude that that means that the subcontractor only gets paid after the contractor gets paid. The way the courts look at cases like this is they consider, well, is that just a timing provision, or does that establish what we call a condition precedent to being paid? In other words, does it mean that the subcontractor will only be paid if the contractor gets paid? And in this particular case, the court granted an order for payment. And what the court said was the clause wasn't sufficiently clear. If you're going to rely on a payment provision like that, it has to say that the subcontractor, it has to say clearly that the subcontractor will only be paid if the contractor is paid, period. It can't just be a mere timing provision. And the idea that is that if the subcontractor supplies their services and materials, the work is approved, you better have a pretty clear provision if they're not going to be entitled to payment. That was the thinking of this court. As I've said, there's a conflicting line of cases on this, which we've talked about, so that Timbro Court of Appeal decision from Ontario. The other thing in this case was that the subcontract incorporated the terms of the prime contract between the contractor and the owner, and that provision had a straight 15-day payment requirement as between the contractor and the owner from the time that the application for payment is made or approved, and there was nothing provisional about it, and that term was incorporated by reference into the subcontract just because the whole contract was. So that makes things, that made things a little bit more confusing as well. So essentially what the court's saying is where there's any confusion, we have this rule called contra proferentum. It's a Latin term in law, which means that contract's going to be construed against the party who drafted it. So if the provision sounds vague, if it's ambiguous, then the court's generally going to, or at least in many cases, is going to construe it, if they have a choice, against the party who has drafted it and is seeking to rely upon it, more to the point. So the courts are saying a clause like this, it has to be really, really clear, at least according to this Manitoba decision, in order for the subcontractor to rely upon it. Okay. Yeah. The difference isn't that the courts agree on whether it needs to be clear. The difference is that the courts sort of agree on what is clear and what isn't. So the debate is when one of these provisions is a mere timing provision, and when it's a conditional payment provision. So I'll just looking at another one very recently in 2015. There's this Walwyn Electric case. This is an electrical subcontractor who ran up against a payment provision. And in this case, I think all of the payment certificates had been certified that included the electrical subcontractor's work. And then towards the conclusion of the project, the general contractor and the owner got into some kind of dispute, and the owner wound up holding back, I think, $150,000 from previously certified payment certificates that had nothing to do with the electrical subcontractor's work. And the general contractor tried to rely upon that to say, well, there's a pay when paid provision. We don't have to pay you until we receive all the money from the owner. And the court said, no, wait a second, if this subcontractor's work has been certified, you can't rely upon a payment provision to hold back money on the basis of some other adjustment to the to payments that's made after the fact. So that seems fairly obvious, but that's sort of another way that those provisions have been interpreted. Liquidated damage provisions, just very quickly, the takeaways from a liquidated damage provision. A liquidated damage provision is essentially a provision that says if you miss a certain date with respect to the completion of the work or with respect to the achievement of a certain milestone of the work, you're going to have to pay damages on a calculated basis, either a daily, weekly, or monthly basis. And they will typically set out the amount of the damages that are going to accrue. And so the test on a a lot of parties will ask, when is a liquidated damages provision enforceable? The general rule is a liquidated damages provision cannot be a penalty clause. It has to be seen as what we call a genuine pre-estimate of the damages that a party is going to incur in the event of a delay. So the things that the court will look for are, did the parties actually turn their minds to what it was going to cost if this project was delayed? Did they undertake a calculation? Did they negotiate what that amount is going to be? If they did all of those things and they did their best to come up with a genuine pre-estimate, then it's more likely to be enforced than in a situation where there's just an arbitrary amount that it's imposed upon either one of the parties for delay. So you'll see contract clauses that say things like, this isn't a penalty. This is a genuine pre-estimate of damages. So that's great, but it's also sort of, it's important for there to be facts that support that. Like, what did the parties actually do to arrive at that genuine pre-estimate? Did they just say it's a genuine pre-estimate? Or did they actually go to did they undertake some measures to achieve that? Often, liquidated damages provisions will go together with, on the mirror side of them will be like cost savings provisions or bonuses. So if a contractor finishes the work early, then they might achieve a bonus, and the enforceability of that bonus might be given the same interpretation. Other types of similar provisions, if you might have a cost incentive for, or a cost, I won't call it a penalty, but cost consequences for not, achieving certain project objectives, like obtaining LEED status for a building, or getting or hitting a certain operation date so that revenue can start generating, that sort of thing. But the key on those provisions is, what were the parties thinking about when they negotiated the liquidated damages provision? And if I can indulge you, could I get about 2 more minutes, Brendan?
Absolutely.
Yeah. Okay. So I'm going to quickly run through these last 2 things, because you're lucky to have Sandra here this afternoon, who's got, I guess, a substantial presentation devoted to this Bhasin decision. But I want to talk about it very, very briefly in the sort of from the pre-contract perspective. So without going through all the facts, because you'll hear that from Sandra, what our courts have basically said just very recently is that all contracts have this general organizing principle of good faith. The courts have said that's how they should be. That's how they should be construed. And inherent in that is there's a duty to act honestly in the performance of a contractual obligation. So that doesn't mean that you have to give up the advantages that you have under the contract. It doesn't mean that you have to sort of hand over the keys to the other side and just let them do whatever they want. But what it means is that you can't act capriciously, arbitrarily, and quite candidly, you can't lie or mislead the other party in the performance of your contractual obligations. Now, ever since this decision has come out, and I think Brendan would probably say the same thing, every statement of claim, every statement of defense that I've seen, or most of them anyway, in substantial construction cases has relied upon this case. And now every party in a construction dispute accuses the other party, it seems, of being, of not satisfying this duty of honesty. And of course, sometimes there are cases where these are very real concerns. So this is something that I think is going to have a significant impact on the way that construction contracts are interpreted. And just looking at it very quickly from a pre-contractual perspective, boy, if I open the door on tendering law, I'll be here for another hour, not just 2 minutes. But our courts have, I talked about competitive tenders before, and our courts have said that there's a duty to treat competing bidders fairly in a tendering context. We had that sort of in a tendering context. The courts are saying now that you've got a duty to be honest in the execution of all contracts. So I would say that extends to the tendering phase now, the performance of a construction contract. So you can't mislead the other party to obtain an advantage. You certainly can't lie to the other party to obtain an advantage. And I made facetiously, I made the remark at the outset, people might be thinking, well, what was happening before this decision came out? But what it does is it creates And it's not to suggest that everyone was free to just lie to each other all the time before, but what it says is that the courts have recognized that this is a duty that's owed, and it's a duty probably that so you can't contract out of typically a duty like that so easily. So you've got it's something that has to be taken into consideration on a day-to-day basis in the performance of a contract. Now, the consequences of breaching a contract in this way, because it essentially becomes a contract term, are the basic rule is you wind up, the other party winds up being entitled to be put in the position that they ought to have been in had that duty not been breached. So if you mislead someone into doing something and then you figure that out months and months and months down the road, the damages for something like that can be severe. So it's a very interesting development at law, and I would look forward to, you'll have an interesting presentation from Sandra on that. On this arbitration litigation issue, I'll just make a couple of very quick comments. So many of you will be familiar with the difference between arbitration and litigation. Arbitration is a private process. So I talked about mediation already, which is just a facilitated negotiation. Arbitration is like a private court, a private process where you have a decision maker who's going to rule on what the parties are entitled to at the conclusion of a full-blown trial like you would in a court process. Given the time, without sort of getting into a detailed discussion of that, the issue that the Supreme Court recently looked at, and I'm sorry, I would urge you to sort of look at my slides you can see sort of a summary of the differences between arbitration and litigation. But scrolling ahead a bit, the decision that our Supreme Court looked at very recently is what are the appeal rights from an arbitration? They're very limited. And essentially, the sort of the point to take away from this Satva decision in 2014 from the Supreme Court of Canada, and it's a very different topic now, I know, but I'm just going quickly, is that historically, the interpretation of a contract was treated as a question of law. And the courts in the UK, for example, will often still treat them that way. And in the Satva decision, which was outside, nothing to do with the construction context, there was this dispute over the date at which shares should be priced, and with respect to someone's share purchase option. The court looked at this notion of whether contracts are really a question of what we call mixed fact in law, and what implications that has on appeal rights from an arbitration decision, and whether an arbitrator's decision should be appealed or whether deference should be shown to an arbitrator. In other words, should we say, this is a factual issue, the arbitrator is the one who heard the trial, and we should respect the arbitrator's decision, and we should typically not overturn it. And that's basically what happened. Ultimately, after many, many, many levels of appeals in courts, our Supreme Court said that an arbitrator's interpretation of a contract is an issue of mixed fact and law, and so the arbitrator doesn't have to be correct in their findings. And as I said, this is kind of a lawyer's topic, but they don't have to be correct in their findings. They have to make a reasonable decision, and deference is going to be shown to that arbitrator's decision. So what does that mean for everyone in the construction industry? Essentially, it means this. When you have an arbitration provision, and when you decide to arbitrate your construction contracts, the parties should understand that typically, subject to different agreements, you could work out agreements on appeal rights, you're going to have very limited or no often appeal rights coming out of an arbitrator's decision. Now, depending on your perspective, this could be a very, very good thing. Like if the reason you want an arbitration provision in your contract is because you want the benefits of arbitration over litigation, so you want control over the process. Brendan at his firm has one of the best construction arbitrators you'll find anywhere, Duncan Glayholt.
You get your check afterwards.
Yeah, no, and he, and so so it's very common. There are a lot of others like Duncan who sit on these panels and hear arbitrations, and you get, if you want to choose an experienced arbitrator who knows the construction industry rather than taking the luck of the draw, which is sometimes what you get when you go to court. You don't know who your judge is going to be. When you want control over the process in terms of getting the arbitration heard quickly, and you want those benefits, but also you want finality of your decision. What this decision means is that it's going to be over at the conclusion of your arbitration. So that could be a very good thing, depending on your perspective. The downside of it is if you feel that you don't have an arbitration decision that you're happy with, it's very difficult to appeal it. And so whoever that person is, whatever kind of arbitrator they may be, you're deferring to their decision. Not everyone's going to be right all of the time, and when they make that decision, you're stuck with it, right? So that's one perspective. But the other perspective is you're going to have sort of a final resolution of your dispute, and the courts have basically said when you're talking about contracts, and most construction disputes are disputes over contracts, the arbitration is going to lead to a final decision.